Welcome to the deep dive. Ever wondered how business disputes actually get resolved over in Zambia?
Yeah, it's a good question.
Well, today we're going inside a specific part of their legal system. It's called the Commercial Division of the High Court.
Mm-hmm. Specialized court.
Exactly. And we've got this really interesting document from the Zambia Institute of Advanced Legal Education. It's called Commercial List Procedure.
Right. That's our main source for this.
And we're going to use it to sort of break down how this court actually works. We'll focus on its big girl, which seems to be, well, speed and
It's
efficiency.
trying to cut through the usual legal delays.
Yeah. So think of this as your quick guide to understanding how commercial law works in that specific context without getting totally bogged down in jargon, hopefully.
Definitely. Look, if you're doing business in Zambia,
Hmm.
or maybe you're just curious about how different legal systems handle the fast pace of commerce.
Which it definitely is.
Right. Then this deep dive into the commercial division, it should give you a really solid understanding of its unique approach and, frankly, why it matters.
So our mission here is to cut through the legal speak
Uh-huh.
and just pull out the key things you need to know about how this court aims for that speedy justice in business cases. Okay, so let's start at the beginning, the foundation.
Where did it come from?
Well, our source points out that the commercial division itself is actually grounded in the Zambian constitution,
Hmm.
Article 133.2 specifically. It was amended back in 2016.
Okay.
But interestingly, it didn't start as a full division. It began as something they called the commercial list.
Ah, right. The terminology.
Yeah, and you might actually still hear people use both terms commercial list and commercial court kind of interchangeably.
Because the underlying procedures didn't totally change with that constitutional amendment, right? It was more of an evolution.
Seems like it. So basically, if you hear either term, just know they're talking about the same thing, this dedicated section of the High Court that handles business lawsuits.
Got it. And so when a commercial case starts, it gets filed specifically in the commercial list registry.
That's right. And it has its own registrar just for these types of cases.
And there's a specific judge in charge.
Yeah. The Chief Justice designates a judge in charge, and there are other judges assigned who also specialize in commercial matters.
Makes sense to have dedicated personnel.
Okay, so what actually counts as a commercial action? What gets heard here?
Good question. Order 53, Rule 1 defines it. It says it's basically any lawsuit that arises from transactions relating to, well, commerce, trade, industry, or just business in general.
So pretty broad then.
It is, but the source emphasizes a key point from the definition and how it's interpreted. There really needs to be some kind of transaction between the parties, a
Yeah.
deal, an agreement, something like that.
Right, not just any dispute that happens to involve a business.
Exactly. And to make it clear, the source even gives some dictionary definitions.
Helpful.
Yeah, like a transaction is a piece of business, buying or selling. Commerce is trade, especially international. Trade is the general buying, selling, swathing. Industry is making goods, often in factories. And business, well, that's the whole activity of making, buying, selling for money.
So it covers a really wide range of business dealings.
It does. It casts quite a wide net.
But just as important is what it doesn't usually handle, right?
Absolutely. The source points out that if you're looking to challenge a government decision, what's called judicial review, that typically doesn't land in the commercial division.
Why is that?
Well, the thinking is that judicial review falls under administrative law. That's a whole different branch dealing with how public bodies work.
I see. So those cases generally go to the general division of the High Court.
That's usually the case, yeah.
Okay, but what if it's, a bit borderline, or maybe a case starts in the wrong division? Can it be moved?
Oh, definitely.
Yeah.
Order 53, Rule 11.1 specifically allows a party to ask a judge to transfer a case, either into the commercial division or out of it.
And when can they ask for that?
Anytime before something called the scheduling conference. We'll definitely need to talk more about that conference later.
Okay.
But ultimately, the judge gets the final say on the transfer. That's Rule 11.2. They'll look at the issues, the law involved, and basically decide what's the most efficient way to handle it.
Right. Efficiency seems to be the watchword here.
It really is.
And this is where things get, well, really distinct, isn't it? Once a case is in the commercial division, its own rules take over.
That's a crucial point. Order 53 rules. Our source is very clear. If there's any clash or inconsistency between these rules and the general High Court rules,
Hmm.
for commercial actions, Order 53 wins. Rules 2 and 3 spell that out.
So these rules are specifically designed for this court's purpose.
Exactly. The source calls it a business court and a fast-track court. And to make that happen, the rules are designed to be, and I quote, stringent with strict timeframes.
No messing around.
Pretty much. Think of it like an express lane on the legal highway, designed purely for speed and efficiency in commercial matters.
Okay, so if you're starting a case, how different does it look compared to the general division?
Well, interestingly, the very first step, how you actually commence proceedings, it's quite similar.
Oh, really?
Yeah, whether you're in the commercial division, which, by the way, is mainly in Lusaka and Kitwe, or the general division, which operates more widely,
Uh-huh.
you usually start by filing a document called a writ of summons, and alongside that, you file a statement of claim, which details your case.
So the initial paperwork looks pretty much the same.
On the surface, yes, but the content requirements, especially for the formal arguments, the pleadings, that's where we start seeing the commercial division's specific rules kick in.
Right. Let's talk about that statement of claim, or if the defendant files their own claim back, a counterclaim. What are the rules there?
Okay, so Rule 6.1 is pretty strict here. It says these documents must clearly state the material facts you're relying on, and they have to show a clear cause of action, basically, a valid legal reason for the lawsuit.
And if they don't, if it's vague?
Well, the court can step in, either on its own, or if the other side applies, you can strike out the claim, set it aside, or even dismiss the whole thing.
Wow. So you need to be really clear and precise right from the get-go.
Absolutely crucial. No room for waffle.
Okay, that's the claim. Now, what about the defense? This sounds like a really big difference in the commercial division.
It is a major one. Rule 6.2 states the defense must specifically traverse, meaning address or respond, to every single allegation of fact made in the statement of claim or counterclaim.
Every single one, specifically.
Yep, it's not optional. And Rule 6.3 drives this home. A general denial, just saying I deny everything, or bare denial, like I don't admit that, without explaining why. That's just not good enough.
It won't cut it. So what happens if you don't specifically deny something alleged in the claim? What's the consequence?
This is key. Under Rule 6.4, if your defense doesn't specifically tackle an allegation, the court deems it admitted.
Admitted, as in accepted as true.
Exactly. It's treated as if you've agreed to that fact. And this can even lead straight to what's called judgment on admission for that specific point.
So the court can rule against you on that fact without even needing evidence.
Potentially, yes. The source mentions a couple of important cases here, like Kwambwati versus Ziwago Bonsai and China Henan versus Mwanj contractors. They really underscore this point. You have to be specific in your defense.
So that really forces a detailed, point-by-point response. No hiding behind vague denials.
Precisely. It's designed to narrow down the issues in dispute very early on.
Okay, now let's get into something that sounds absolutely central to this whole fast-track idea. The scheduling conference. What is that exactly?
Ah, yes. The scheduling conference, governed by Rule 7.1. This is a really core part of the commercial division's machinery.
When does it happen?
Quickly, within 14 days after the defendant files their appearance saying they'll defend the case and their defense, the judge has to call this meeting.
14 days. That is fast.
It is. And the main purpose, according to Rule 7.2, is for the judge to really take control, to issue directions, basically set out the timetable and the steps for the whole case leading up to the trial. And this is done in consultation with the parties.
So the judge is driving the schedule right from the start.
Very much so. It's judge-led.
Oh.
Think of it as setting the game plan and the deadlines early on, so everyone knows exactly what needs to happen and when.
And the source mentions it's important for the actual lawyers handling the case to be there in person, not just, a junior associate.
Absolutely critical, because this conference is where the rubber meets the road on timelines. The lawyers need to be there to agree on the schedule for things like filing any replies, discovery, exchanging documents, witness statements, all of that.
Right. They need the authority to commit to the deadlines.
Exactly. Getting that buy-in and agreement up front is meant to prevent delays down the line. Rule 7.2 actually lists a whole bunch of things typically agreed on. Reply, defense to counterclaim, discovery lists, inspection of documents, witness statements, skeleton arguments, even estimating trial length and setting dates for status checks and the trial itself.
It sounds incredibly thorough, covering all the bases early.
That's the idea. Get organized, get focused.
You mentioned witness statements again. That seems like a really big shift from traditional trials, doesn't it?
Oh, it's a huge difference, especially for speed. Rule 7.3 in the commercial division requires parties to exchange and file their witness statements, usually not less than 21 days before the trial.
Okay, so the evidence in chief is basically on paper beforehand.
Exactly.
Right.
So when you get to the actual trial, the witness doesn't typically give their main evidence verbally by being questioned by their own lawyer, what's called examination in chief.
Their written statement is their main evidence.
Precisely. It stands as their evidence in chief.
Wow. I can see how that would shave off a massive amount of time in court.
Absolutely. It focuses the live trial time on cross-examination and re-examination.
So, what needs to go into these witness statements? They must have to be pretty detailed.
They do. Rule 7.3 says they need to contain all the relevant facts the witness can speak to relating to the claim, defense, or counterclaim. And crucially, they have to refer specifically to any documents in the case bundle that support what they're saying.
Are there specific formatting rules?
Yes, the source mentions referring to the English court rules, specifically Order 38 of the Rules of the Supreme Court, the old white book, as a guide.
Okay.
So you're looking at things like writing in the first person, I saw, I did, including the witness's full name, address, job, employer status, telling the story clearly, usually chronologically, numbered paragraphs, using figures for numbers and dates, double-spaced page numbers, clearly identifying any documents mentioned.
And the witness has to sign it.
Yes, and if they can't, there needs to be an explanation. Plus, critically, there has to be a statement of truth. The witness confirming they believe the facts stated are true.
So it's a formal, sworn-style statement just submitted before trial.
Pretty much. And as we said, it means the trial focuses on questioning that statement, cross-examination by the other side, and maybe some clarification questions in re-examination. A very different feel to a traditional trial.
And it seems this practice is catching on elsewhere, too.
It is. The source notes that Order 19 now requires witness statements in other high court divisions as well for certain types of cases. The efficiency benefits are clearly being recognized.
Makes sense. Along with the witness statements, you also mentioned skeleton arguments.
Yes, Rule 7.4. Also required in the commercial division. These are basically concise written outlines of each party's legal arguments.
So the judge gets a heads up on the legal points.
Exactly. They have to be filed along with list of authorities, the cases and laws you're relying on. It helps the judge prepare and understand the core legal issues before the hearing even starts.
Again, all about preparation and efficiency.
That's the recurring theme.
Now, despite all this planning, things can still go off track. Adjournments asking to postpone a hearing are often a source of delay in legal cases. How does the commercial division handle requests for adjournments?
Very, very strictly.
Uh,
Rule 9.1 repeats the general rule you see elsewhere. Adjournments are only granted in compelling and exceptional circumstances.
okay, that sounds standard.
And you usually need to give 10 days notice if you're asking for one, same as Order 333 generally. But here's the commercial division kicker.
Uh-oh.
If the judge thinks the reason for asking for an adjournment is weak or frivolous, as the rule puts it,
Yeah.
they can slap the requesting party with a court hearing fee. The source mentions K500.00, though that might change over time. Plus, they have to pay the other side's wasted cost for the delay.
A financial penalty for a weak excuse.
You got it. And crucially, that fee has to be paid before the next hearing date is even fixed.
Ouch. So it's a real disincentive.
Definitely. The Jamas Milling versus IMEX International case is cited as an example of this. It basically says, don't ask for a delay unless you have a really good reason.
And what if the party ordered to pay the fee just doesn't?
Well, Rule 9.3 says if the party asking for the adjournment fails to pay, their application might just be dismissed. If it was the other party ordered to pay for some reason, Rule 9.4 says they might lose their right to be heard, and the court could just proceed without them.
Serious consequences, then.
Very serious. It shows they mean business about sticking to the schedule.
And it sounds like even the process for telling the court a lawyer can't make it is formalized. No quick phone calls or letters.
No, absolutely not. If counsel can't attend, they need to either send another qualified lawyer as their agent, or they must file a formal application, a notice of motion, backed up by a sworn affidavit explaining exactly why they can't be there. Proper reasons required.
Right. And what about getting a case back on the list if it gets struck out because, say, the claimant didn't show up?
Again, stricter rules apply. Rule 10.3 mentions higher restoration fees, and Rule 10.2 imposes a strict 30-day time limit to apply to get the case restored. Miss that deadline, and it's considered finally dismissed.
And if it happens again?
Rule 10.4 is brutal. If the claimant fails to appear a second time after the case has been restored once, the judge will dismiss it immediately. No second chances on that front.
How does that compare to the general division?
It's much stricter. In the General Division, Order 35, Rule 6.2 gives the judge discretion on whether to even charge a hearing fee for restoration. Here, it's mandatory fees and hard deadlines.
So the message is clear. Show up, be prepared, and don't cause delays.
That's the essence of it, yes. Keep the wheels turning.
Okay, quickly covering a couple of other procedural points. Serving court documents, delivering them to the other side. Anything special there?
The requirement itself is pretty standard. You need proof of service. Usually that's done via a sworn affidavit of service, and you typically annex a copy of the document that the other party signed to acknowledge they received it. Standard practice, but needs to be done properly.
Right. And we mentioned mediation or arbitration earlier. That comes up at the scheduling conference.
Yes, Rule 8 allows the judge at that scheduling conference to refer the parties to mediation if they think it might help settle things. That follows the process in Order 31 of the Maine High Court rules. Or they might suggest arbitration if that seems more appropriate. Trying to find alternative ways to resolve the dispute without a full trial.
Makes sense. Now, what about those urgent applications you sometimes need during a case, like asking for an injunction to stop someone doing something? Interlocutory applications, they're called.
Yes. There are specific rules for those too in the commercial division. Rule 10.1 says these applications go directly to a judge in chambers, not the deputy registrar, which can be different in the general division where sometimes the registrar hears them initially. But the really key thing here is Rule 10.8.
What does that say?
It says when you make one of these applications, you must file skeleton arguments at the same time.
The skeleton arguments again?
Yep. Outlining the facts, the law, the cases you rely on. And you have to provide copies of those cases and statutes too.
So you can't just file the application form and hope for a hearing date?
Absolutely not. The source uses the example of applying for an injunction and lists all the documents needed from both sides. And it explicitly states, if you don't file the skeleton arguments and authorities, your application simply won't be scheduled for hearing.
Full preparation is non-negotiable then.
Seems that way. You
Yeah.
need to have your legal ducks in a row from the moment you file the application.
I also see a rule about cases being dismissed if they just sit there doing nothing.
Yeah, Rule 10. If 60 days pass after filing without any progress being made at all,
Yeah.
a party can apply to have the whole action dismissed for want of prosecution.
Yeah.
Basically, get it off the books if it's just languishing.
Is that unique to the commercial division?
No, there's a similar provision, Order 19.8, in the General Division too. It's a general tool to clear out inactive cases.
Okay. And if a hearing date has been set, but maybe a lawyer realizes they have a clash or some other issue, can they ask to change the date?
Yes. Rule 12 allows for an application to vary the hearing date, often to bring it forward if there's an anticipated problem. But you need to file a formal notice to vary hearing date, and importantly, give at least 10 days notice before the original hearing date.
So again, proper notice, formal process.
Consistency.
Now, the source briefly mentions distinguishing between terms like matter dismissed, strike out, and set aside. Can we quickly clarify those? They sound similar.
Yeah, they can be confusing. Briefly, matter dismissed usually means the case is over, finished, removed from the court list. If it was dismissed on its merits, meaning the judge decided the core issues, you generally can't bring it again. If it was dismissed for a procedural reason, like non-attendance, you might be able to start a completely new action, but the original one is dead.
Okay. And strikeout?
Strikeout often means something is removed from the court record, maybe temporarily. It could be the whole case or just a specific pleading or application. It might be possible to get it reinstated or amended if the problem is fixed. It doesn't always have the finality of a dismissal.
I see. And set aside.
To set aside, an order or judgment means the court cancels its own previous decision. This usually happens if there was a procedural error, like one party wasn't properly notified, or maybe the judgment was entered by default. The effect is to nullify the earlier order, allowing the issue to be properly decided.
That's helpful, thanks. So after that initial crucial scheduling conference, how does the court check if everyone is actually following the plan?
That's where the status conference comes in, or sometimes called a compliance conference. Rule 7.6 allows the judge to summon the parties back specifically for this.
What happens there?
The judge basically reviews the case progress.
Yeah.
Have the directions from the scheduling conference been followed? Has discovery happened? Have witness statements been exchanged on time?
The compliance check.
Exactly. And if someone hasn't complied, the judge can make further orders, including orders for costs against the party who dropped the ball.
And is this when the final trial date gets locked in?
Usually, yes. Once the judge is satisfied that everything's in order, all the free trial steps are done, they'll then set the firm date for the trial to begin.
Is there a similar conference in the general division?
Yes, Order 19, Rule 5-1 provides for a status conference there too, but the timing mentioned is typically not less than 31 days before the hearing. Again, potentially a slightly longer time frame than the commercial division might aim for.
Right. Everything seems geared towards that faster pace.
That's the clear impression.
Okay, so if we try and, boil this all down, this deep dive into Zambia's commercial division really paints a picture of a court laser-focused on efficiency and speed for business disputes.
Absolutely. The key mechanisms seem to be those very specific, quite stringent rules.
Uh-huh. And that early active involvement from the judge through the scheduling conference.
Right, setting the timetable up front. Plus, the use of pretrial witness statements is a major factor in streamlining the actual trial.
And of course, the significant consequences if you cause delays or don't follow the rules, the fees, the risk of dismissal.
It all points towards keeping cases moving. So, for anyone involved in business in Zambia, understanding these procedures is, well, it's pretty crucial. It tells you how disputes are likely to play out and really highlights the need for prompt action and careful preparation.
Definitely emphasizes sticking to those strict timelines.
No doubt.
Okay, so with all that covered, here's maybe a final thought for you, the listener, to mull over. Given this undeniable focus on speed and efficiency in the commercial division, how do you think these very strict procedures balance that need for quick resolution, which businesses often want, against the fundamental right everyone has to a fair, thorough hearing?
That's a great question. Is there a trade-off?
Yeah, what are the potential trade-offs when a legal system puts such a premium on speed? Could corners be cut, or is it just cutting out unnecessary delay?
It's definitely something worth thinking about. Where does efficiency end and potentially sacrificing thoroughness begin? Or does it manage both?
Food for thought. And look, if this overview has piqued your interest, maybe you want to dig deeper into those specific rules, Order 53, or look up some of those cases we
There's
mentioned.
always more detail if you want it.
For now, thanks for joining us on this deep dive.